May it please the Lord. My Lord, may I be permitted to, my Lord, move an I on Monday, my Lord, in a pending case. We filed it day before yesterday. And developed. There are two matters, my Lord. Yeah.
May I please listen, my lord? My lord, I beg to mention item number 31, which for hearing, my lord. I mean, earlier government was directed to my lord, bring the instruction, my lord. Today, my lord, I seek for adjournment, my lord. Only after a week, my lord.
What are your instructions? You are for the government.
No, lord.
Who appears for the government?
Mr. Pathak is there.
Oh.
31.
You want time today?
Today, my lord. After a week, 1 week, my lord.
Give him time. Next.
I love it.
Wait, please, your lordship. I beg to mention item number 19 of today's list, my lord. Letter may be come up after 4 weeks, my lord. Enable me to file affidavit in opposition, my lord. Item 19. Yes, my lord.
But last time the government advocate was asked to take instructions.
I am appearing on behalf of federal government, my lord. Last time maybe even my last opportunity may be given.
You appear on whose behalf?
Yes, my lord.
You appear on whose behalf?
I'm on Union of India, my lord.
You wait till the matter is called out.
Yes.
Please, your lordship. Lordship, in regard to item number 25, lordship, I seek for an adjournment, lordship. I am appearing for the appellant on behalf of senior advocate Mr. DC that he is slightly indisposed today, lordship. Can it be taken after 2 weeks, lordship?
Lordship, I beg to mention item number 18, Lordship. Lordship, in this matter, we were to file affidavit. We have sent it for vetting, Lordship. We
Mr.
are yet
Pathak.
Lordship.
Mr. Pathak,
Yes, Lord.
next week.
Lordship,
File by next week.
can it be 10 days, Lord? Lord.
If you have sent it, how long will it take to come from your office?
Lordship, it's not after. Lordship.
Next.
Lordship, with the consent of the other side, I'd like to mention item number 7. Lordship,
Item
senior-
number?
7, your lordship.
Yes.
Senior advocate Dr. Ashok sir is out of station today, your lordship. Matter may be adjourned for.
You are mentioning for whom?
On behalf of Dr. Ashok sir.
So the other side, who appears for the?
My Lord, I am for the department, Lord.
You have to file reply.
We have already filed, Lordship. They have to file their reply to the counter affidavit.
And therefore we are saying, you have to file reply.
Yes, your lordship. 3 weeks I may be allowed.
3 weeks. Next, at the request of.
Mayor, please, I beg to mention also item 38. I taken consent for others that my friends appear for the appellant, I am for the respondent.
Any. Next.
Adjourn for the our name has been reflected in the reply. Our name has not been reflected.
Huh?
Our name has not been reflected as a respondent. Item 30. We are reflected because in IA we are appearing, our name is reflected, but today it is not reflected. So 38, Lord. I'm the respond number 1.
Next.
May it please, my lords, with the consent of the learned counsel for the appellants.
One second. The respondent is reflected.
With the consent of the learned counsel for the appellants, I beg to mention item 37, my lord. I appear on behalf of Mr. KP Pathak, learned counsel for the respondents. There is some personal inconvenience on his part today. May I pray for a week's time, my lord? I'm obliged.
My Lord, I would like to mention item number 30. My Lord, Mr. P.N. Goswami, Additional Advocate General of Assam, is unwell today. He was to take up the matter. So maybe a week may be given, my Lord.
Item number
30.
30.
30.
Fully good. Next.
Oblige, my Lord.
Item number 1 of daily list for motion.
Yes, Mr. Sharma, what are your instructions?
Yes, may I please your lordship, today we will be filing an affidavit, your lord.
File next week,
Yes, sir.
next week.
Item number 2.
Actually, in this case, we were informed yesterday that the learned counsel for the UGC is indisposed. He has gone for treatment to Chennai. Lordship, can it be taken up on 14th or 9th of December, Lordship? Obliged, Lordship.
Item number 3.
Please, your lordship, my lord. In
Recurrent
pursuance of
proceedings have come.
LCR already, my lord, received, my lord. My lord, the ground of challenge mainly, my lord, the permanent eligibility was, my lord, granted, my lord, but no separate petition has been filed, my lord,
It can be granted, counsel.
my lord. And second, my lord, thing, my lord, I am the grade 4 employee, my lord,
You
And-
read para 17
my lord.
of the judgment.
May I read, my lord?
So cruelty is proved. Your salary is 42,000.
42,000, my lord.
Huh.
But the 6 lakhs, my lord, at a time, my lord, it is, my lord, more harsh, my lord.
We'll convert it into 2 installments.
My lord, it may be, my lord, 4 installment, my lord.
He has also to maintain herself.
My lord,
Huh.
my lord, I admitting, my lord,
His judgment is of July.
July, my lord.
We are in November, so July 30th. So August, September, October. You have already consumed three
My
months.
lord.
Deposit 50%. We'll convert it into two installments. You don't challenge the divorce.
My lord.
You don't challenge the divorce.
No, my lord.
You only challenge 6 lakhs of rupees.
My lord.
We'll convert it into installment, EMI. Flex,
My lord.
flex EMI.
And my lord, I have to receive instruction, my lord, from my client, my lord. My lord.
That would be third installment. That would be the last installment.
My lord.
What can be done? 6 lakhs of rupees today, even if you invest it, he is not going to get, he is not a senior citizen that he would get 1% more.
My lord.
6% is the general interest. So 6 lakhs, and if you, what would it come to 6%?
6%, my lord,
36,000
36,000
per year.
for year, my lord.
So 3,000 per month. Even in MSCT cases, it is more.
My lord.
So it is very reasonable judgment. And if you don't challenge the divorce, naturally alimony of 6 lakhs 2023 is nothing. Installment, yes, because you are also earning 42,000.
My lord. But I
No
have to,
other
my lord,
interference will make.
another family member, old age, mother, father, my lord.
Therefore, we have some sympathy.
My lord.
But we have to take care of the lady who is alone now in life.
My lord.
No other interference will be made. We'll record that you don't challenge the divorce.
My lord.
We'll record your statement. that you don't challenge the divorce.
My lord.
Huh?
My lord, as my lord, she already deserted, my lord.
Huh?
Already deserted from my house, my lord.
No, therefore, let us be very clear.
And
See,
it is,
turn
my
to
lord.
page 69. Please turn to page 69.
'69, my lord.
The operative order, the marriage solemnized between so and so is dissolved forthwith. Now, you don't challenge this finding,
My lord.
we'll record this statement. Or you challenge this finding.
I don't challenge, my lord. So far as my lord, amount is concerned, my lord, I have challenged, my lord.
You don't challenge the dissolution
My
of
lord.
marriage.
No, my lord. My lord,
Or you are challenging only the quantum,
my lord, only quantum, my lord.
only quantum,
Quantum,
not the
my lord.
divorce.
My lord.
You are not aggrieved by the fact that the marriage has been dissolved by the family court.
But I have filed a WS, my lord. My lord.
No, before us,
Before my
in
lord,
this appeal, what are you challenging?
my lord, unbreakable, my lord, breakdown, my lord. I have not challenged the divorce, my lord.
So
It is not
your
possible.
only grievance is the quantum.
Quantum, my lord.
Telling that we put this statement.
But we'll have to record your statement that you are not challenging the divorce and you are aggrieved only by the quantum.
My lord, may I record, my lord.
Do you have instructions?
My lord.
You have instructions from
My
the
lord.
client.
Because as per my client instruction, my lord, it is never possible to reunion, my lord.
We are not on it possible or not, because if you see your prayers in the memo of appeal at page 11, you have challenged the whole award,
My
whole judgment. Therefore, for recording concession, you also should have instructions from your client. Tomorrow we pass the order, a review may come that I had not authorized my counsel.
No, my lord, my lord. I have already, my lord, instructed, my lord. Is not challenged, my lord, divorce, but regarding, my lord, amount, my lord.
You file a short affidavit to that effect
My lord, my lord,
Of your client.
my lord,
from your client saying
My
that you are not challenging the divorce.
my lord.
Next Thursday.
Oblige.
The number 4,
She makes it okay.
Hmm.
Both are-
May I please, Lordship? Lordship, through this matter appeal, we have challenged the judgment and order passed by learned additional district judge FTC Bishwanath Shailesh, Lordship, whereby the learned court granted a sum of 17 lakh rupees as permanent alimony against us, Lordship. We are challenging the quantum, Lordship.
What is your salary?
Lordship, it's I am a professor, Lordship.
What is your salary?
Lordship, I don't have the exact.
Turn to page 25 and read para 28 of the judgment.
Lordship.
Don't say that you don't know. If we know it, at least you should know as a counsel. This must have increased after 7th pay commission. The evidence of the petitioner on affidavit as filed by her in respondent is an assistant professor working with the Assam University, and she believes that he draws a monthly salary of 70,000.
Lordship, they have said that they have believed, they have not submitted anything.
That is why we are asking you to read that.
Yes, Lordship.
Notice second in proceeding. lower court judge. You appear for the respondent?
Yes, your lordship.
So no formal notice is required. Next. Let LTR be there.
Lordship.
Next.
matter number 5 and 6,
May I please, your lordship? For item 5 and 6, learned senior counsel KLC sir will appear. Kindly may pass out for the time being.
Lord, in these two appeals, if your lordship recall, my lord, on the last occasion, lordship indicated in a particular paragraph of the impugned judgment passed in one of the appeals, it was mentioned that the selected candidates were not implemented. And therefore, your lordship indicated whether the matter can be handled and he had to take instruction.
Mr. Chaudhary was to make a statement.
Yes. If that instruction my learned friend has to give to his learned series. What instruction does he have about that, my lord? Because the
Do
lordship
you
was
have any idea about it?
No, my lord, senior counsel will deal that.
We'll pass it over.
Right.
2 o'clock.
Of that.
Item number 8,
8 to 12.
Well, in this case, I'm led by Senior Counsel Dr. Saraf, but he has some personal difficulty today, but I pray for some next.
This is item number 8. Your matter is already to be mentioned adjourned. This is serial number 8. 7. No, Rupe is not there. You are mentioning which matter?
8, my lord. 8 to 12 are all connected matters.
8 to 12. He called out only one. What is your request? Dr. Saraf is not available.
Yes.
Even Mr. Pathak is not available.
No, my lord. In fact, he
You
was
should not have
informed.
mentioned the matter. Next.
item number 13,
Please,
My
your
lord,
lordship.
whatever about the timing, my lord, AG will appear on his legs in another court. Timing.
The issue in this irritability is, my lord, whether the UGC regulations are binding on the state government. That is the issue.
Hmm?
Whether UGC regulations are
I think
binding.
now it is covered by a recent Supreme Court judgment on Sardar Patel University.
My lord,
It
the
is,
judgment,
it is now reported.
I think, my lord, that is Gambhir Dan. Perhaps, my lord, that is the latest. Yes, my lord.
Gambhir Dan.
I have to refer to that, my lord.
Gambhir Dan only.
Yes, my lord.
After Gambhir Dan also a little different view has been taken.
My lord, I checked, I didn't find anyone.
I had read it, but I could not lay my hands to that judgment yesterday.
So let
Gambhir
me-
Dan is reported because now it has come in STC also.
I don't know, my lord. I checked yesterday also whether it is latest judgment.
No, after Gambhir Dan, there is one same reiteration, but there is one more judgment.
I'll try
I
to
had
get.
read it in live law. Therefore, I remember, but I could not retrieve it. Otherwise, Gambhir Dan is now reported. You must
Yes.
be knowing it. It has come in STC also. Let learned advocate general be here. Oh. Next.
item number 14,
Yes.
May I
sir.
please, lordship, to this writ appeal, my lord. The appellant has challenged the order dated 27/9/2021 passed by the honorable single bench of this honorable court, my lord. Whereby, my lord, the single bench has held that since in the earlier litigation, my lord,
Now turn to page 73 first.
my lord,
What were the prayers in the earlier bit? Read loudly
my lord,
and turn to page 91.
my lord. It is therefore prayed that your lordship may please to issue rule calling on upon the respondents to show cause as why direction should not be issued to the SLC to recommend the name of the petitioner to appoint for appointment of the petitioner on compassionate ground against the existing vacant post in accordance with the DLC Dhubri recommendation dated 10/4/2015 and or call upon the respondents to show cause as to why the impugned SLC dated
Impugn, it has to be impugn order which you have forgotten, but we can read into it.
My lord,
Impugn order of SLC dated 27/11/2022 should not be entered.
interfere with my lord.
Therefore, you had already challenged the order of SLC dated 27/10/2020.
My lord, this is subsequent,
Not subsequent. Now turn to page 91.
my lord.
This is the order. In view of the SLC minutes dated 17/11/2020,
My
the
lord,
writ petition stands closed as infructuous. You
My
have
lord.
challenged the same thing.
my lord,
So
this
there
is the subsequent writ petition which I have annexed, my lord.
Mr.
Kindly see,
Subsequent or you had challenged that there is very order.
my lord.
Therefore, the learned single judge is right in saying that it amounts to res judicata. There is no fault in finding of the learned single judge. You can't
my
be permitted to agitate the same
He-
thing again.
If your lordship permits me, my lord, my kindly. This is writ petition number 4943, my lord,
Correct, counsel, we are not on writ petition.
my lord.
In that very writ petition, you had challenged the same order of SLC. In this petition also, you have SL the same order. That is the question.
No, my lord, earlier writ petition was for different reason, my lord.
We were reading
No,
the prayer at page 73.
This is subsequent writ petition where
Maybe,
the
but you,
learned
you-
single
you-
judge has passed the order, my lord.
now you see the state and the departmental have referred to the order dated so and so. Therefore, we took you to 91, page 91.
My lord, this is the annexer, my lord. Annexer of the,
Page 91 is the order of earlier petition.
yes, my lord.
And then you want to differentiate by saying that I had not prayed challenge that. But
Yes.
that was the development during the pendency of the earlier. petition.
During the pendency of the earlier writ petition, my lord.
Where have you stated this before the learned single judge and even in your petition?
My lord.
Show me.
My lord, in my petition, my lord, writ appeal, I have stated, my lord.
Not writ appeal.
My lord, writ
Before the
petition, my lord.
Writ petition. You should have mentioned it.
My lord. Today, my lord.
File a review before the learned single judge.
Well.
Counsel. File proper review before the learned single judge. Now, what were the prayers prayed for in the earlier petition?
My lord, in the earlier writ petition, since my case was not considered by SLC, the earlier writ petition was filed, my lord. During pendency of the writ petition, my lord, said earlier writ petition, my lord, filed SLC meeting dated 27/11/2020, my case was considered, my lord.
Now, therefore, you go to page 23.
My lord,
This is the prayer that you had prayed in the earlier petition.
my lord,
Am I correct?
yes, my lord.
Now, here your prayer was should not be issued directing them to do needful in the compassionate ground.
For appointment of the petitioner or compassionate ground.
This was your prayer.
Yes,
Now, while this petition was pending,
my lord,
SLC considered your case on 27/10/2020
my lord,
and found that you are not eligible.
I am not eligible,
Therefore, this writ petition was disposed of.
my lord.
Did you have any occasion to challenge the order dated 27/10/2022? 20 passed by SLC?
My lord, I did not have, my lord,
Then you should have told that in your petition,
my lord.
which you have not.
Go and file a review.
Go out, file a review. You have a good case. This differentiate you are supposed to show to the learned single. judge.
Yes, yes, my lord.
That where is the question of res judicata?
Yes.
Who appears for the government? See, you turn to page 91. Mr. Goswami, learned counsel for the state respondent, has produced the minutes of the SLC dated so and so. Because earlier first paragraph his grievance was that his case is not recommended to the SLC. Minutes of SLC dated so and so, which shows that the petitioner application for compensation has been rejected due to the following. in view of the SLC minutes so and so, the writ petition stands closed as infructuous.
Lord.
Now his prayer at page 23 was that my case should be considered.
Lordship.
His prayer was not that he was challenging 27/11/2020 order of SLC.
Lordship.
He had no occasion because that order was not in existence when he filed the first writ petition.
Lord.
Therefore, where is the question of res judicata? This you should have avoided in your memo of appeal. We unnecessarily had to consume 15 minutes to find out what is what at home while reading the papers. You have not even avoided that ground in your memo of appeal. Anyway, it doesn't make any difference.
My lord, in grounds, I have mentioned, my lord,
No, you say generally that it's not res judicata.
my lord.
Do you understand, Ms. Bhattacharya ji?
Lordship.
We intend to remand this matter back to the learned single judge
Lordship.
instead of asking him to file a review.
Lord.
Because it can be termed as res judicata.
Lordship.
He may not ever, but we don't want petitioner unnecessarily to tax himself, dispose of.
I'm obliged.
Matter number 15.
Mr. Counsel, think it over for some amendments in your writ petition now that we are remanding it. You are supposed to tell this to the court, otherwise it would amount to suppression.
My lord.
Don't come back with another ground here. Next.
May be watched. Well, in this case, the important judgment is addressed, my lord, 59 kindly be seen, lordship. The grievance against the petitioner lordship, that is plus 57 lordship, the findings. Lordship. There are 15 onwards, 15, 16 and 17 lordship.
You are challenging the order in review.
Yes, also lordship. Well, that order is, my lord, at this kindly be seen at plus 97.
Or so knowledge. Next.
All right, my lord, may I pray, my lord? My lord, one post may kindly be directed to be kept vacant, lordship. My lord,
You can pray, but we may not grant it.
my lord, my submission is that.
Prayer, there are no limitations on prayers, but there are restrictions on granting every prayer that is prayed for. Next.
All right, lordship.
Matter number 16.
Yeah, please. Petitioner is aggrieved against non-permissiveness of her service as the subject issue
No,
in
but
common stream of this.
what was the date of your joining?
That is the case. Actually, my lord,
Because
6/4/2010,
no,
I was joined. Subsequently,
Sir,
the
your-
principal of the institution insisted me to issue another joining letter. Accordingly, I
no, that is
issued.
the, if a person, it is just, I'm just giving an example. A person is in a particular cadre
My lord,
in the same organization.
my lord,
Say a person is working as an assistant registrar in Guwahati High Court.
my lord,
He appears for the examination of judicial magistrate first class.
my lord.
And he joined on 3rd of November 2022.
My lord.
Then he's joining in the cadre of JMFC is today. The earlier service cannot be clubbed into. Because your own statement is there. Now go to page 7.
My lord.
Or rather para 7 of the judgment. Earlier you were some music teacher.
Computer instructor,
A computer. Read para 7.
my lord.
So it is a contention. There are factual matters will come out from that.
My lord.
Please read.
The learned counsel appearing on behalf of the respondent was 6 subject that the petitioner was appointed on 5/4/2010. But strangely, in the attendance register should produce at Annex 4. To repeat petition would show that the petitioner had put her signature on 2/4/2010 and 2 prior to her appointment, which cannot be conceived of unless and until the certificate issued by the principal of the school on 10/12/2011 is taken into consideration. He submits that the appraisal of certificate dated 10/12/2011 would show that the principal of the school had certified that the petitioner was rendering service as computer teacher from 8/4/2004 to 9/4/2010. He further submits that the document individual information to be furnished by each employee, a document which was submitted by the petitioner for the concerned authority under their signature on 9/2/2011. In the said document, the petitioner had categorically mentioned that she had joined the school on 10/4/2010 and prior thereto, she was worked from 8/4/2004 to 9/4/2010 as computer teacher. The non-mentioning of the said document by the petitioner in her writ petition amounts to suppression of material facts. Further to that, he submits that even by way of an affidavit in reply, the petitioner had not explained why the said document was not brought to the record or have denied the existence of said document. This is therefore a simple case of suppression of material fact. In order
Okay,
to
you can
mislead the
skip-
court.
You can, counsel, you can skip and now come to the finding at para 9.
After hearing the
So
party,
it was your own case that you have joined on 10/4. Now read that.
in fact, it was also my case that I was joined on 6/4.
That is why I was giving you that example.
That is why, my
You
lord,
know, you were working as a computer teacher.
my lord, why I am agreeing, my lord, I am challenging a particular order of the director dated 28/6/2016,
16.
passed by the director.
Yes,
While passing the order by the director failed to take into consideration of the fact that the earlier direction of this honorable.
that is neither here nor there.
My lord, yes, my lord, the earlier direction given by this honorable court is specifically stated that the director, while passing the order, have to take into consideration of the attendance register, my lord. But that
No,
is
no.
my case, my lord.
No, no,
In the attendance register,
Now-
my case will
now-
be
now
reflected.
you-
I have
Mr.
put my
Counsel.
signature,
Mr. Counsel, listen for a moment.
my lord.
Attendance register has to be taken into consideration. You
My
are
lord, that
absolute-
was not taken into consideration.
Listen for a moment.
My lord.
Now, do you agree that you are appointed on 10/4/2010 or not?
My lord, I am in such a position, my lord, the head of the institution,
You
who
forget.
allow me to, my lord, join
you-
as a teacher.
No,
He subsequently asked me to, well, I cannot deny the superior authority, my lord. He
Now-
says that nothing will be happen to you.
Now
You
you
submit
forget-
another joining
Mr.
report,
Counsel, please bear with her.
my lord.
It is your own case and the appointment letter also says that you were appointed on 10/4.
No, my lord, at appointment order, my lord, your lordship, kindly, I annex the appointment order, my lord. That is in the writ petition, my lord.
Yes. Go to that.
My lord, it was issued on, my lord, page 31.
No,
5/4/2010.
You turn to page 67. Who is Nirja Deka? Who is Nirja Deka?
Myself, my lord.
Now read this order, or this letter written by you.
My lord, that is my case, my lord. I have also annexed in
No,
my
no,
writ petition, my lord.
we are coming to your case. You will,
But same
at
document,
most some rectification may be
but
required.
same document, page 34.
You please read this first.
With reference to subject cited, I have honor to inform you that I have joined on my duty as subject teacher in Assamese of so and so school on 10/4/2010 at 10 a.m. My lord, I have to write this letter because the principal of the institution asked me to do this. My lord, I am in the venture stage, my lord. as per dictation of the head of the institution, we have to work, my lord. Otherwise, we will be nowhere, my lord.
No, whether you are everywhere or nowhere is not the question. The
But
question is,
The
on
fact remains that,
when will you, when were you appointed?
my lord.
That is the question.
Well, the page 32, my lord.
Not
This
32.
appointment order, I joined on
32.
6/4, my lord. That is why the learned
No,
signatures
no,
while
therefore,
passing the
even
earlier
if
order
we-
in 2013, my lord.
Even if you join on 6/4,
My lord.
how could you mention your name in the attendance register on 2/4/2020?
My lord, that is on 1/4/2000.
Therefore, if you
1/4/2010.
Therefore,
1/4/2010, I resigned from the post of computer teacher, my lord.
No, we are not on that.
Unofficially, the head of the institution asked me to continue. Without issuing the letter, I joined on 2/4. That is my case, my lord.
No. Therefore, you have not.
Subsequently, appointment order was issued on 5/4, my lord.
Can a person be appointed before appointed letter?
My lord,
It happens only in
my
Assam.
lord,
it seems.
it's a Bhanstar stage, my lord. As per, my lord,
See, Mr. Counsel, it is 80 most your highest case is that you were appointed on 6/4/2010.
my lord, why I am pressing that attendance register equal to verify, my lord, in the attendance register, it is clearly demonstrated that
Therefore, we
name
are-
of the
we-
private
we-
respondent is,
we are ready to examine. We'll call for the record ourselves.
my lord,
We want to do that exercise.
my lord.
But the question is that there can be cart before a horse. If you are appointed on 6, you can't be attending the court as school as a teacher on 2/4. It is
I
impossible.
was asked to continue, my lord. On
You were a
1/4/2010,
computer teacher.
1/4/2010, I resigned from the post,
Computer teacher.
my lord.
That services are not to be clubbed to this. This is a separate cadre.
That is why I am saying on 1/4/2010,
register.
I resigned from the post of computer teacher, my lord. On 2/4, my
But
lord,
you are-
I have been allowed to
Mr.
continue.
Counsel,
As a-
allowed to continue as a computer teacher.
Allowed to continue as a subject teacher. my
No,
lord.
that is-
Subsequently, on 5/4,
then
the
you-
appointment
you-
order was issued.
You file proper proceedings before the tribunal. You file proper proceedings before the
My
tribunal.
lord,
If you
at
want
least
to-
that attendance register may be verified because
I will
in the
verify.
attendance register, everything will be clarified.
No,
The
no,
name of the private respondent is put above the margin, my lord.
At the most, you are favored by the principal with greatest respect. He had no authority.
My lord, if I may submit, I'm appealing for response number 6, my lord. If he is harping on the attendance register, which is at page number 35, my lord. Your lordship
show
would
the
notice-
original register.
My
In
lord,
the original register.
my lord.
Who is for the headmaster?
Headmaster, principal can go there for an act.
Bring
Perhaps,
the
my lord, the
original
notice has
register.
not been issued.
Director, we know that it is provincialized. ये झगड़ा ही provincialism का है. हम जानते हैं.
My lord?
That is the real dispute.
Yes.
Otherwise, you would not have asked for rate. And we want the appointment letter because if nobody can be appointed before the appointment letter, date of appointment letter. If principal has to do it, it is principal's mistake.
The attendance register may be called for, my lord.
We'll call for everything. Call for the original appointment letter as well as the register.
Madam, if lordship will have page 37 for a moment, I'll just show one thing, my lord. Even the private respondent hearing, my lord, she claims to have joined on 10/4, but she signs the register on 9/4. So there is something wrong.
No, something wrong means the school management is doing all this mistake. It is very
Right.
clear.
Correct.
But what actions you have taken for 12 years? Nothing. Next.
I'll have looked.
Item number 40 of supplementary list.
It will go with 27 and 28.
Lordship. In this case, your lordship, notice has not been issued, your lordship.
We'll issue notice because
Yes.
this is similar to item
27 and 28, your lordship. Yes, 27, 28.
28.
Lord.
He may not be knowing, but I am knowing. Notice.
Lord.
27 and 28, it's on the same day. 4 weeks. Next.
Lord. Obliged.
But ultimately, I was just thinking, as it is in my mind, I don't know whether it will be conducted before me or not. Where is the adjudication of this amount? By which authority?
This is, my lord, we are challenging 17-1 also.
Adjudication is a labor court will decide.
No,
Under
that is why I am
17(2).
saying. The observation made by the learned single judge that his X payment is made.
Yes.
Is based on adjudication done by which authority?
Yes. Adjudication will be done by the under,
No, his quantum which is fixed
yes.
is based on what?
This base, there is no basis, my lord. That's a whole. Some figures in which head nothing was there.
But where is your ground on that?
No, that we have 17, our whole case.
No, you are challenging the
No,
power.
we are challenging 17(1) also. There
Power
has to
itself.
17 law. It is under the rule 36, my lord, before the secretary. We have filed 2 writ petition. There cannot be a sub-delegation. This is our case, rule 36. They have to file a proper application. There has to be a subjective satisfaction. Where is that? Their notice has to be given to us. No notice was given to us. On what figure, your lordship rightly, on what figure they have arrived? 1 crore 86 lakhs. On what figure? Which head?
1 crore 83 lakh.
Yes.
This is your lordship, this amount is your lordship, this area salary, your
No,
lordship.
I have seen that.
Lordship. When your lordship, my case is this, your lordship, that at no point of time they have raised any dispute regarding this amount, your lordship. In fact, they have admitted that this calculation, they are satisfied with the calculation.
Even if there is for example, if there is an admission, then the adjudication under 17 would not be required at all.
No, lordship, only when dispute is raised, your lordship, then 17(2) will come into operation. That is my.
Agree. That is what I am
Lord-
saying. That
Lordship.
dispute would not have been there. There would not have been reference under 17.
Lordship. And my case is that your lordship, they have not raised any dispute, therefore there is no question of referring it to the.
But they have to give a notice to me, my lord. 17(1). Where is that notice?
I was
No
only
notice.
I was only thinking aloud because one thing is certain that something is due and payable.
Lordship.
Something is due and payable.
Yes.
Prima facie, subject to hearing on technicalities, there may not be delay in making payment to the person. So if you can sit together and test out something, it would be.
Right.
Lordship. If your lordship fixed in the last week of November, your lordship.
That is what I have done it.
Lordship.
We'll
Because
try.
you are absolutely correct. They will not, we may not be able to come out from this technical requirement. This will necessarily remain here in the court. And then ultimately, 2 possibilities are there that the court may ask the authority to hear both of you and decide again. That will entail unnecessarily time, and the person, whether this newspaper is an ongoing.
No, your lordship, it has been closed.
That also I have.
Closure, exact closed.
Therefore, please take a call on that.
Lordship.
We can't force upon, but
Yes, will.
please try to be true
Yes.
to your name. That is what my feeling is. Right?
Right.
So when you are there, he is there, we can hope some.
Yes.
You don't need any third party to decide your dispute. Not even court. Try to test out.
Yes.
On technicalities, you may be correct, but ultimately, when something is due and payable, the whole soul of the act on which you are raising these issues is to see that the dispute is resolved. And then, anyways, this was my suggestion.
Will try.
We will try.
Yes, next. Deeply.
Oblige.
Item number 17 of daily list.
Mr. Nath, you have to take instructions.
Lordship, I had a confusion here, my lord. It's on my part, my lord. In the website, the next date is shown as 9/11. That is why I have written.
9/11 is a dangerous date, so we don't keep anything on 9/11.
Lordship. Kindly give me 1 week. I'll get the report.
Now we'll keep it on 9/11.
My lord.
9/11 is gone. 9th of November.
Lord.
Next.
Problem.
Item number 19.
Here also they were asking for, you were mentioning this matter.
Yes, my lord, petitioner counsel is out of station, my lord. I have informed him, my lord. And I have received the instruction also, my lord. Here, received the instruction from mail, my lord. I'll file affidavit immediately.
Your next.
Matter number 20,
My lord.
You have to take steps, Mr. Das. Notice. You have to take steps for other side. problem. One of the respondent is not yet served.
My lord.
Who appears for the other side?
My female friend is appearing.
Do you represent all the respondents?
No,
Lordship, I'm BTC only, I'm representing. That is respondent number 5 and 6, Lordship.
So all are represent.
Yes.
Then Mr. Das, there is no problem. Yes,
Lordship, here the pleadings are completed. Lordship may fix up for hearing on any date after 16th, Lordship. AG will be appearing.
he would be appearing.
Yes, sir.
Ask him when is he available in India.
This- Any day after 15th of this month.
15th of this month. And you are not traveling to Bangladesh.
Bangladesh, no, Lord.
Because now we will have to follow every
No,
series
It
for
is
your
not
presence.
like that, Lordship.
Next. So I told somebody who mentioned that you are not available that it depends upon the result of today's match.
Yesterday.
I told your colleague. Fortunately, now I think you will be able to travel. Especially after Zimbabwe's match. Next.
My turn.
so number 21 and 22,
Prakash. Yes, Mr. Chaudhary. So newly added parties have been found.
Lordship had indicated on the other day, Lordship, this, Mr. Ahmed, who was appearing for the thesis, he could have appeared.
But because the report shows that, but till that no step for,
No, that is because I had not taken that. Lordship had indicated that he could appear. So, Lordship, I will take steps.
counsel for the appellant to take step.
Madam, I'm for item number 22. In my case, madam, it has been already admitted. It can be heard also, but they have not filed any affidavit.
This, this is connected with the earlier case, Lordship.
21 and 22.
Yes, therefore, Lordship, both the cases have to be taken up together.
It will have to be heard together, counsel.
My lord.
We will have to hear both the matters.
Okay, my lord.
Next.
so number 23,
That was heard on 26th, my lord. And today your lordship told me to think about it, whether that can be done or not, my lord. So may I suggest, my lord, may I kindly submit page 35, my lord. Page 13, page 39, my lord. Kindly say page 39. The page 39, my lord, after the order passed by this honorable court, and that process has been initiated.
No, that we know. See, the latest material that we have on record, you may not be privy to it, we may tell you. By a communication dated 2nd April 2022, the government has informed the learned counsel, or rather learned advocate, that it may be mentioned that the identification of land for setting up of medical college at Karimganj is under process.
Yes, madam.
So they are doing their work.
All the
They
matter-
can speed up this.
That process has been initiated and some,
So they will take So that is what we were indicating. These are all policy decisions in a way. We can interfere to a little extent, not more. It is at page 92, the letter which we are mentioning.
Yes, my lord, that affidavits has been exchanged.
Ah.
And my lord, that I have also filed the counter affidavits against that particular affidavit.
No,
my lord.
that is there, your counter affidavit are there, but nobody, what inherent right you have? That it should be at this stage, tell us. Tomorrow you will say it should be on MG Road.
No, this is not,
A day will come when a petition will come that instead of convention center, government should have a medical college.
my lord, there are some MCA guidelines is there, my lord.
So
Why?
that they will follow MCI guidelines, doesn't say that it should be opened only. They may take, even today, they are free to take decision that we don't want to open a medical
My lord,
college.
they have taken
We
a
go to that
decision to,
extent.
they have taken a decision to open the medical college.
They
That
can
was
even,
announced.
they can even review. As a citizen, it is okay, you have brought it to our notice, we will record the statement of learned advocate general that it is under process. Otherwise, we can monitor that whether creek is there or not, now land is identified. These are all projects. It can be done overnight. Only because a new district is created out of an old district,
No.
it takes its own time.
No, my lord, that district was constituted in the year 1985, man.
At the 85, whatever it may be. What fundamental right you have? You to first explain it to us.
That is, my lord, in all other districts, my lord, governments are
We-
setting
we-
medical.
we don't repeat that. We ask you the same question. What is your fundamental right?
Fundamental rights.
Do you stay there? Do you stay in that village?
Yes, my lord, my permanent resident at the Koringas.
No, you are practicing lawyer in Guwahati High Court. How can you say that you are a permanent resident of that? Anything is brought by way of PIL. We run Sachivalaya from this state. We'll give appropriate direction to the government. That there is no difficulty. Otherwise, we can monitor this, do this and do that. And because even in the earlier order which you are harping upon, your representation was to be considered. He is closed with a liberty to the petitioner to approach principal secretarial by means of a representative. Nothing more can be done. We'll issue directions that they may take decision as expeditiously as possible. Learned Advocate General, what is the position according
The
to your
position,
information?
it is not only in Karimganj, the other districts also, we have taken a policy decision to have one medical colleges in each district. And as per that decision,
What
Lordship,
do you want?
Lordship, one more line, Lordship, in the assembly also, page 3 of the affidavit. In view of above, it is respectfully submitted that the Honorable Finance Minister has announced in budget for financial year 22-23 for establishment of a medical college at Karimganj, Assam. Further identification of land for setting up of
They have
medical
already
college.
taken a decision. What more do you want? We may expedite the.
In the budget also, in budget, we cannot speak all this without having any decision.
No, but Learned Advocate General, his worry is that when are you going to start it?
No, it is a continuous process. This month also, we are starting 5 colleges, the construction work. And within this, another one is opening next month. So we had 3 colleges in 2010, Lordship. Now we have about 11. Lordship. Yeah, Lordship may take. Lordship. Identification of land is a very cumbersome effort. While we decided to have IIT in Changsari, Lordship, we had to face litigation for 5 years. Somebody wanted in Roha, the other group wanted it in Amingaon, Lordship. It took 5 years. We fought the case in Calcutta also, NGT. Highly obliged.
Item number 24.
May I please, your lordship? Lordship, this case pertaining to detention of the petitioner under Pete NDPS Act, lordship.
Affidavit is
Not from lordship. But lordship, in this case, I am just pointed out, apart from various ground, one major ground is under section 11. I was detained, Lordship, in the, on 20.
Lordship, I have all the instruction, Lordship. Here, Lordship, he has already been released from, yes, Lordship, and he is now arrested in another case, Lordship. I have the details, yes, Lordship.
Let affidavit be filed. Lordship.
Yes, Lord.
Item number 26.
My lord, in this matter, pleading is complete, my lord. So we have agreed upon a date, my lord, December 1st, my lord. This matter may be fixed for admission hearing, my lord.
Lordship, as a fixed item, because Lordship, we come from Burma Beach, Lordship. On December 1 as fixed item, Lordship.
First December, will you come here?
Lordship, yes.
You will go for appeal.
Lordship, if convenient, then on 24th of November, then Lordship.
24th.
Because pleading is completed, Lordship.
Here,
Lordship.
December for a Saturday.
Lordship, yes. Lordship.
My lord, can it be on 5th December? We are led by my lord D. Majumdar, senior counsel in this matter. He has some difficulty in the last week. He told me, my lord.
Lordship. Oblige, you, Lordship.
Item number 27 and, sorry. Item number 29.
Yes, Mr. Pitwa.
Yes, my lord.
May I please, your
There's a problem the other side.
with
lady
due
advocate.
respect, matter may be adjourned for 1 week, Lordship.
Mediation was failed, my lord, there.
Yes, sir. Lordship, we are unable to contact the respondent, Lordship. Lordship. 1 week time may be given. B. Borgohai.
First week of December, correct?
First week of December. Late. Master, Lordship.
Item number 32 and 33.
Your Lordship, Central Excise Appeal is there, Your Lordship, 5/2020, Your Lordship. Your Lordship, my senior is on legs, Your Lordship. Can you fix this matter at 2, Your Lordship? At 2. Hello?
Item number 34.
The petitioner in person is not present.
Item number 35.
May it please, Your Lordship. My lord, this matter is concerning.
Lordship, my affidavit is ready, Lordship, for swearing.
But this is a
And
writ
they allow
appeal,
me
my lord.
one week, Lordship, because
This is a writ
they
appeal.
wanted to file an affidavit, Lordship.
No, generally affidavits are not from writ appeal, you know. Put my, Lordship, please fix a date, you know. Next week.
Item number 36.
May I please, Your Lordship? Your Lordship, can you matter me fixed at 2, Your Lordship? My senior is on legs.
My lord, then on, my lord, on 15 November, my lord, if possible, for your lordship.
Deeply obliged.
Item number 39.
May it please, Your Lord. No.
Mr. Roy reappeared. My lord, possibly is coming, my lord. My lord, a very small issue. My lord, I will take your lordships to the order dated 27/2022.
Mr. Roy is on my senior lordship.
Coming.
He's just in the bar. He's coming from the bar. You'll wait, your lord.
Okay.
The judgment which we have challenged, there the learned single judge, my lord, maybe consciously, maybe unconsciously, set as an appellate court over the another coordinate case. Many observations, which may or may not be, my lord, but there are some way to, I mean, and in the other case, my lord, now which the state has come, their learned single judge did not interfere because the parties were not before the court. So on last occasion, lordship has expressed the view, make them parties, let learned single judge hear the both the, that, my lord, we are agreeable, madam.
My lord, there are two cases. One, which was filed by us, is against a judgment passed in WP number 2725. There was a direction that we have to consider the appointment of the petitioners. But as far as the findings recorded by the learned single judge is concerned, all the findings are recorded in our favor. In only one paragraph, there was an abrupt finding without any basis that since we have found some illegality in this election, so we are directing. But at the same time, since the selected candidates were not made parties, the appointment of those persons were not disturbed. My lord, your lordship.
Now, my lord, everything will be open. Let learned single judge take a fresh call.
And I will have reserved. Yes. I would like to have the cases to be decided on merit.
Liberal.
Item number 13.
My lord, I could look at the decision of lordship was. It is not in the SSA online or is in live law. I could find it. My. I didn't get my view, my lord. The relevant paragraphs will be, my lord, 8.3, 8.4, and 8.5.
It is the other. You. Learned Advocate General, we have got only one copy, both of you.
No, I have gone through this last night, lordship.
No,
I know
no,
this judge.
Preeti's judgment.
My lord Justice Ahmad Shaw.
Even there are two judges.
Yes, I have gone through this judgment, lord.
You can have a copy of.
Yes, my lord, I was about to give him. He said, my lord,
We have, I gone through it last night, lordship.
Yes, my lord. My lord, in West Bengal case, perhaps, my lord, Gambhiran has not been referred to.
State of West Bengal versus India Sundar Das and others.
Yes, my lord. Put for adjournment. I have read it online, my lord.
It is available in live law.
Yes, my lord. That's available. In fact, I downloaded it, but did not get a printout.
It is very recent, October 11.
Yes.
Where Gambhir Gadvi is considered in para 56 of the judgment. So we'll have to hear both these sides. And advocate, sir.
Lordship.
We'll have to hear this matter.
Yes, yes, Lordship may issue notice.
I only cleared the my lord things in the my lord, depending on the decision of the honorable court, the press advertisements are being issued by different universities and colleges, my lord.
At the most, we can say that any further process will be subject to final outcome of
Right.
the office. Because they also need staff.
Yes.
Otherwise, it would unnecessarily affect the education.
Only thing is that Lordship, we do not say that we are not following the UGC norms.
Hmm.
Our case is that we are following the UGC norms.
But therefore, it will be examined on.
It will be examined. No, so far as this case is concerned, Lordship, I think Lordship, the persons who were already part of the subject matter, Lordship, they were appointed and they have joined also, and they are not before this honorable court.
So we are not disturbing anything.
Lordship,
Or
my only submission, Lordship, may be please to only issue notice without giving any observations. At
we are
this stage,
issuing notice on.
only notice, yes.
So you can reply to if you want.
Yes, Lordship, will.
The only thing is I want your colleague to waive so that Mr. Chaudhary may not have to wait for the service. Who are the respondents, Mr. Chaudhary?
The respondents are, my lord, the Union of India was made a party and state Joint Secretary, Director of Higher Education and UGC.
No, respond number 5 is the concerned person. So
UGC.
notice to respondent.
My lord, Mr. A. Somoa, my lord, he has received.
But he hardly comes.
He has not appeared, by lord.
Even in the running matters, he hardly comes. We are waiting for him in one such matter. Notice returnable after 4 weeks.
He appeared before the honorable single judge also, my lord.
I have noticed.
My lord.
So and so, Mr. R.K. Chaudhary, you can request Mr. Chaudhary, I have mentioned it.
My lord. My lord.
Deputy
Yes.
Solicitor General waived for number 1. So and so, for number 1 and 2. 1, 2 and 4. 1, 3 and 4. 2, 3 and 4.
2, 3 and 4.
2, 3 and 4, Lordship.
I is out to Dusty service. You take Dusty service for 5.
My lord.
Next.
Highly obliged, Lordship.
Letter number 32 and
observation,
33.
my lord, that observation, my lord, that.
It will automatically, because we are issuing notice, Mr. Chaudhary, even if it is not there, necessarily we have taken cognizance of the matter. Therefore, we found out a judgment, they will have to come out from that.
Yes. Now we have a reply to that also, Lordship.
Naturally,
Lordship.
your presence is meant
Lord.
for that only.
Highly obliged, Lordship.
Your lordship may kindly fix the date, my.
We have given the date, sir.
I am obliged. I'm sorry.
Yes, Mr. Kyle.
What's the previous appeal by the state, by the revenue? Against the order passed by the
But
CC.
last time somebody appeared and said that it is covered against you. By
No.
judgment where my brother is the party.
No, this is not a cover. They said the appeal is not maintainable. The council, the appeal was admitted on 15/3/2021 on two substantial question of law.
Lordship, the arguing counsel is not present due to some personal inconvenience. So next date may be.
Yes, sir.
Bill number 34.
Serial number?
If the petitioner in person is not present again.
What is it about?
Lordship, the petitioner in person is a contractor in the Department of Education. He has certain grievances against the appointment of chief engineer in the concerned department. Also, he is alleging some criminal offenses for it. He should approach the police.
Is
and
he
he
a
should lodge an
is he a
FIR.
practicing advocate?
Lordship, no, Lordship. He is a businessman and a contractor in the same department, in the education department.
He must be contractor in the same department.
Yes, sir.
So called out twice. The party in person is not present. Even on 13/9/2022. The party in person was not present. To be listed in due course.
Bill number 39.
May it please your lordship. My lord, I will take your lordship to the order dated 27/2022. Your lordship observed that in a short point, the matter will be disposed of. Only on the point of interest, whether 18% interest can be allowed or not.
Who is for the other side?
My learned friend has appeared.
18% interest, anybody used in any even commercial word this way. It's 18% per annum, simple it. I know that, I can read that much English. The lordship, they used my 1 crore, 80 lakh, 10,000. That is not the criteria. You are entitled to interest. The lordship, the order of the judgment of the honorable single judge is this, that if they pay the amount, they return back the amount in 45 days, that the rate of interest will be at the banking lending rate, prevailing rate. That is what we are saying. But if the amount is not paid within 45 days, then the rate of interest will be at 6% per annum. That we have read, sir, but 18% is provided by whom? Which even any financial institute except those private money lenders. Lordship, even under the MSME Act, lordship, the interest is
now
even lending rate. Mr. Counsel, in MSCT now we award 6%. As Mr. Datta is there, I was reminded of MSCT first.
Lordship, may we please to consider that.
On what
This-
basis 18% is awarded? What is, there is no privity of
If-
contract between.
Lordship, if they would have paid within 45
Let me
days.
know it. Now, 1 crore is already paid to you.
My lord, 1
Principal
crore 80
amount
lakhs,
has been
10,000 paid.
But,
Principal amount
but,
is
but
paid.
the interest at the bank rate,
That you leave it to us. But 18% is out of question. We'll ask the bank to pay you interest at the lending rate.
the lending rate, Lordship, if a
On what
person.
basis 18% is awarded by the
Lordship,
learned
this
legal-
was a commercial transaction, and as per
Maybe.
the section 34 of the CPC, Lordship, the interest ought to be granted, Lordship, with the monthly rest, quarterly rest, or quarterly rest,
34
Lordship.
and all that,
He-
you
he-
file a suit for that.
Then I
Really
leave it to
speaking,
your
the
lordship.
learned single judge ought not to have granted any interest, but still, however, it is granted, we respect it. 18%, we are on 18%. 18% is out of question. It is unheard.
But see the conduct of the appellate.
Conduct, yes, therefore they will be
They have
settled.
cheated the
There
auction
is no
participant.
question of cheating, mister. You are in a commercial world. They are also in a commercial world.
Lordship, in the auction notice, they have mentioned that they are in the actual physical position of the plot of the land.
That is now all over. You have
All
received the principal amount.
Then your lordship may. But when EMI fails, lordship, if a borrower does not pay the EMI, they impose penalty. Then legal expenses, then miscellaneous expenses.
That analogy is not to be counted when you are there. You are a commercial person. Therefore, you should not be out of loss.
Then
Loss of
lordship,
interest.
lordship at the bank prevailing rate may be awarded with monthly rest.
No, one monthly
That is
rate.
permissible under section
It
34
is
of the CC.
permissible, but it is discretionary.
Because this was discretionary, that discretionary power has been exercised by the honorable
That is
single
what
judge.
we say, that we'll say that it is wrongly exercised. On what basis? Till a single judge has awarded 18%.
Then your lordship may fix the rate of interest.
We can understand you are entitled to interest because money was retained by the bank. There is no doubt about it. But it has to be some.
For
sense
6
of-
years.
That is why interest. If it would have been for 6 months, nothing would have been awarded to you. Hold, Mr. S. Datta. Sir, senior counsel assisted by also for the appellant and Mr. S.P. Roy. S.P. Roy learned count for the response. Feeling aggrieved and dissatisfied by the judgment and order dated 23/2/2022 tendered by learned single judge in writ petition civil number 4423 of 2000 CPC then 4423 of 2018. The appellant bank has referred his appeal mainly only on the ground of award of 18% interest on actual. It is a single judge while disposing of the writ petition directed the respondent back to refund the amount in question, that is rupees 1,80,10,000 in words rupees 1 crore and 80 lakhs and 10,000 to the petitioner, along with interest at the prevailing banking rate from 4/10/2016 within a period of 45 days from today. It is however directed that in case of further delay for the period stipulated, the interest could be rupees 18,000 per annum on the actual amount. The learned counsels at the bar are at 18 that as per the order dated 207/2022 passed by this court, the appellant bank has paid rupees 1 crore and 1 crore 80 lakh 10,000 back to the petition. Correct. Mr. Datta, learned counsel appearing for the appellant has submitted that the learned single judge has committed an error in granting interest at the prevailing bank rate and on failure 18% interest. It was submitted by Mr. Datta, counsel for the respondent appellant bank. That as such, the appellant bank was justified to deny the refund to the respondent in the backdrop of the fact that the land in question has not been properly demarcated till date. It was also contended that the award of interest is not sustainable and further 18% interest on the actual amount is being imposed as if it is a penalty. It was contended by Mr. Tattal and counsel appearing for the appellant that even as per the RBI norm, the interest rates have been lowered, and in such view of the matter, it was unreasonable to impose 18% penal interest on the appellant bank. So therefore submitted that the appeal be allowed. For contra, Mr. Roy, SP Roy, learned counsel appearing for the appellant, appearing for the respondent, has opposed his appeal and has referred to section 34 of the CPC. It is the contention of SP Roy, learned counsel appearing for the respondent, that is provided under section 34 of the CPC. The interest can be awarded on monthly basis. It was therefore submitted that the impugned judgment and order is legal and proper. Mr. SP Roy, learned counsel appearing for the respondent, further contend that the appellant bank, even though it's a public sector bank, kept a huge amount of rupees so and so deposited by the respondent, even though the land was not even demarcated. And under such circumstances, according to Mr. Roy, the huge amount was held up without any fault of the respondent, and therefore it was contended that the appellant bank is liable to pay even penal interest as the principal amount was not returned within a period of 45 days. Mr. SP Roy, learned counsel appearing for the respondent, further contended that the interest awarded should be on monthly basis. On the aforesaid grounds, Mr. SP Roy, learned counsel appearing for the respondent, contended that the appeal being meritless deserves to be dismissed. Paragraph. No other or further submissions, grounds, or contentions have been raised by learned counsels appearing for the party. Having heard the learned counsels appearing for the party, at the outset it deserves to be noted that the principal amount of rupees so and so has already been received by the respondent. It is no doubt true that the respondents are entitled to interest. Yes, the amount was a huge amount of so and so was kept by the appellant bank since 4th of October 2016. The record indicates that the appellant made effort to get the land in question properly and to get the complete title of the land earmark for the purpose. However, the same could not be possible, and it is also a matter of fact that the property into bracket land bracket stores in question was subjected to the condition of as is where is based. However, as the appeal is only on the limited aspect of award of interest, we deem it fit not to further examine the state question. The only paragraph, the only question which arises for our consideration is whether the respondents are entitled to interest as interest at the prevailing banking rate from 4/6/2016 or not, and whether penal interest at the rate of 18% per annum or not. In order to answer this question, even if reference is made to section 34 of the CP, Civil Procedure Code, the state provision also speaks of 6% interest.
No, for commercial lending, it is higher. Subpara. It was a commercial.
Even if it is considered to be a commercial transaction as contended by Mr. S.P. Roy and counsel for the respondent, the same cannot exceed the contractual rate of interest, or where there is no contractual rate of interest agreed, it should match with the nationalized bank in relation to commercial transactions as provided under first proviso of section 34 into bracket 1 of the CP. It is no doubt true that huge amount of rupees so was lying with the appellant bank on 4/10/2006. There is no contractual rate as far as the transaction is concerned. Having considered the totality of facts,
My lord, as lordship may be pleased to go through section 4 of the interest act. If there is an obligation, then the interest will be.
now we have noted your argument. We deem it fit to restrict the rate of interest to 6% from 4 and caution set aside the order of 18% per annum is by way of any penal interest. However, such interest shall be payable from 4/10/2016 till the date of its realization.
Not to be lending rate is
Appellant shall deposit, shall pay directly the amount so calculated, the amount of interest so calculated to the respondent within a period of 2 weeks from today. As the respondents were paid back the amount of rupees 1,80,10,000 later, the appellant is settled with cost of rupees 25,000 to be paid to the respondent. The appeal is disposed of accordingly. The impugned judgment and order stands modified only to the aforesaid extent.
Much of it.
Lordship 6% even
From 4/10/2016. From the date, we don't want to say that the transaction was of 90 days, so after in January 2007.
at least the bank lending rate interest will be given. Or is a retired major lordship.
Next, in view of the peculiar facts and circumstances arising out of this appeal, and more particularly, though the money was retained by the appellant bank, the fact remains that the land oblique property in question was entangled in other
Lordship, first,
discrepancies, including demarcation.
the first order of your lordship is that this appeal will confine only to 18% interest.
Yes.
Now the whole prevailing interest rate has been also gone.
18% because they were late, so 18 would apply. Directly 18 would apply.